So it's just chapter 7, really?
Yeah. And then whatever we're supposed to read in this book that I didn't read this week.
What are you teaching tonight?
What's that?
What are you teaching tonight?
Real property.
Nice.
And they had twigs to give away.
What?
They had twigs to give away.
Why?
For Sazine.
Probably because they're talking about feeding.
Because that's so unnecessary.
You can't do that anymore, can you?
No.
No.
Here's a rock.
Here's a rock. You own my house now.
It's so goofy too because, like, I mean, I wish that I understood, like, how a deed of trust secures a lien and what a lien is.
Right.
Things like that. I don't remember that stuff. I
Remember
remember.
what a lien is?
Well, I mean, yeah, I do.
It's a promise to pay back a debt or to get your house.
No. The deed of trust secures the house against the lien.
Oh, the lien.
The lien is just a promise.
A lien is the mortgage.
Right, but the
I
deed of
mean, like
trust
second
secures it.
position, third position, all that fun stuff. Like if you don't pay back your AC guy, it puts a lien on your house.
Mm-hmm.
It's
Like the
gonna
construction liens and stuff like
But
that.
it's going to be in second
I mean,
position
that's-
because he has to pay
Mechanics
the interest.
Yeah, mechanic lien, construction lien. They have construction lien too.
Yeah,
But yeah, all that stuff.
that's all fun.
I didn't know. I forgot all that. So like,
I remember like the joint tenancy and stuff like that,
yeah.
but I don't remember anything about like easements.
Oh,
I remember at first.
I'm in the middle of writing for right now. So there's 5 types.
I know there's a bunch of different
Well,
types.
there's actually 2 types and 5 ways to create one.
There's an implied and explicit.
Okay, so here's the deal.
Those are ways to
Oh.
create.
I'm gonna let you out at 7 tonight, because I am going to Hawaii on Friday, and I am woefully behind.
I'm supposed to say not that.
No, it's not bad, I'm just like throwing on Hawaii for 16 days. But I am still behind, like scary behind. So what we're gonna do is we're gonna cover some things. I dictated an essay question on my way to the home that Ron is printing out for me. I'm gonna give that to you guys at the end. You just have to write it sometime in the next 2 days, let's say by Saturday, at the latest. Write out the question, do it like it's a part, it should take an hour. So that will make up for the fact that we got out of here a little early. But it's a good precursor to getting, ready for midterms.
Practice midterm.
And then what that means though, it's like practice midterm, exactly. But what that means though is that you won't have reading this week for next week. We're not going to, we're gonna fall behind a little bit in our reading. So I'm gonna cut you guys some slack. Don't do any new reading between now and next week. Okay?
Deal.
Yeah. So, and I'll talk to, I don't know if it's Heidi teaching next week or Nicole. I think it's Heidi that's gonna teach next week. Because then Nicole is gonna teach the week before your midterm. And she's gonna handle the midterm review. Because Nicole and I have already written the midterm question, which is kind of questions. Because remember on Wills and Trust, you get 2 essays, no multi-state. Okay, so she's gonna do the, I'm just gonna get the calendar here, so that we're all on the same page. Because it's nice to not have to read for a week. I mean, I realize the reading is really quite enjoyable. It's like the People magazine of law cases, right? At least that's what I think. Yeah, so on the week, so next week, which is the 17th, Heidi will cover the non-probate transfers and planning for incapacity. So you don't have to, because you read that for this week, so you don't have to do any reading for next week, okay? Because this will end up becoming week 7, okay? Because I always allow, there's a little cushion in the back part of the syllabus for if we have to catch up a little bit. So, so we'll be fine. You'll be fine. What will probably, week 8, which will then be the following week, the limits on freedom of disposition, that will end up falling down to 1031, okay? So
after midterms.
right, so really for all intents and purposes, you don't have any new reading between now and midterms. Okay, are we all clear? Because again, I have an extra wiggle week in the final, the final week or so. So I set it up, so it's really intensive, you do like all this reading, but then it's nice because it does taper off a little bit towards the end, okay?
Ready.
So that's the deal. We're gonna cover leftover questions from trusts. And you're gonna get this question that she's printing out for me. And just sometime between now and Saturday, you guys write it out and email it to me. And then I will have Heidi go over that next
Tried to
week.
do a quick format.
I know. Didn't you like it on my note?
That's what I said. It sounds like she was dictating this.
I was dictating in the car. I was driving down. Thank you.
Might be missing on.
I'm gonna check real quick, yeah. That's perfect. Wow, I do good work. I do say so myself. Okay, so everybody clear then? We know no more reading between now and midterm. What you already read for week 7, you're gonna cover next week with Heidi in technically what you read for week 6, you're gonna cover in week 7. Week 7 will fall to after the midterm, and then week 8 will be your midterm review with Nicole.
Correct.
Okay, so you have a little breather. Okay, did everybody read the trust? Did everybody take the time to read the trust?
Yes.
Questions on that, because it's so important that you kind of understand this. I think it's a rather ethereal concept, right? Like what is a trust? So it's really like, it looks like a contract, right?
Mm-hmm.
So does it make sense when you understand the trustor is also the trustee? And at some point in time, the trustor is no longer the trustee, right? Because of the debt or incapacity, right? Okay.
Oh, it's cool you included digital assets in there, considering like.
So that's a new thing, right?
The last one?
Yeah, the last section, we added digital assets. That's a,
Oh, yeah.
so even though this is like my form, it's constantly changing. So digital assets got added, I think it was about 2 years ago. The CEB is what we use for continuing education, the bar. They put all those practice guides and everything out there. Those things are great. Like when you're a new lawyer, you get free CEB access, and it is wonderful. There's forms on there, there's pleading examples, everything. I mean, if you don't know what you're doing, you go on CEB and you start reading, right? So oftentimes when things like this change, like digital assets, we wait to see what the model language is that the state bar puts out. So then we incorporate the model language into our document. So yeah, digital assets is a big thing. Now, I have an issue right now where we have a guy, did I tell you about this guy that died with a Bitcoin account?
No.
Yeah, so I'm opening up a probate for the sole reason because the guy committed suicide, very tragic, don't know why. Didn't leave a suicide note or anything. But 2 months before he died, you could see where he took out large withdrawals from his investment account and bought Bitcoin. And we know he had a Bitcoin wallet because he had bought one on Amazon. We can see all these things that he had, but we don't have the passcode. And he put like $200,000 in this Bitcoin account that we think is worth quite a bit of money, because even though it ran up and it ran down, it's still up. But the thing with Bitcoin is if you don't have that passcode, supposedly you can't get it, period. And based upon all the research we've done, CEB everywhere, a couple CE classes, pretty much the consensus is if you don't have the blockchain password, you don't get access to the Bitcoin. So what we're doing is we're gonna open a probate, so we have letters testamentary in order for probate, because he died intestate, no will. Single guy, no kids, so his mother and father basically inherit his estate. We're gonna open the probate, we're gonna get legal authority, and then I'm going to try and approach, Bitcoin, Coinbase or whatever it's called, and say, hey, what's in the Bitcoin account? I told the parents, I said, I think we're gonna get nowhere. But we're also gonna issue a subpoena to Verizon because his cell phone, I don't know why his mother did this, but closed his cell phone account and then didn't have all the emails. I'm like, but what, maybe there's stuff in his old emails and text messages, because she remembers before she closed the cell phone account, she remembers seeing digital pictures on the phone or something. And I said,
They should still be there.
but it's the text messages and that.
They should still be there.
Yeah, I don't know, she can't find them. So we're gonna issue a subpoena to see if we can get anything. Because there's hundreds of thousands of dollars with this Bitcoin, where does it go? Nobody knows. That's why I wouldn't do Bitcoin.
Just know with
That's
Verizon, they require either a signed authorization or a judge's signature
On the
Because-
subpoena?
on a subpoena.
Really?
Because we've tried to subpoena Verizon records for our own clients before,
Uh-huh.
and they turn back to us and
Really?
say you either need authorization or a judge's signature on it.
An authorization from whom?
The
The
account,
dead guy?
the account owner.
But wouldn't that be what my letters testamentary in order for probate provide? Because my executor, in this case, my administrator, steps into the shoes of the dead guy.
Then that should be fine, as long as you get them to sign the authorization and attach the letters of testamentary to
That's what
it.
we're gonna do.
Yeah,
Yeah.
then that should work, yeah.
Yeah.
I just know Verizon's
Very sticky.
super
Yeah.
particular.
So anyways, that's why we now include digital assets, because it's kind of a big thing. Yeah, that's a good observation. If you look at my trust from 3 and 4 years ago, not there. But if I do an amendment to a trust now, I look to see if one of my old trusts doesn't have it, or if someone else's trust doesn't have it, even then I'll add it in the amendment, right? The other thing too, that's of course newer things in my world is section 9, where we discourage litigation, where we have a mediation required clause. So we're forcing people to try alternative dispute resolution if there's a dispute between beneficiaries, and the trust pays for the cost of it. So those are things that are new, that you didn't used to see alternative dispute resolution clauses in trust. But so any other questions on that, on the trust instrument?
There was, so in the contest clause, I noticed how it said, notwithstanding the foregoing, a contest shall include any action described above in the arbitration proceeding and shall not include any action described above solely in mediation, not preceding the filing of a contest with the court. So does that mean that you can contest it as long as you mediate the contestation without filing a formal contest to it?
Yeah, so that's a good question. So years ago in California, we used to have a safe harbor rule in probate that said you could file a petition that said, hey, dear judge, I intend to file this petition, but before I do, please tell me if this is or is not considered a contest of the will of the trust. So it was a way that you could prophylactically go in and make sure that you weren't going to disinherit yourself by whatever action you brought. So about 6 or 7 years ago, the probate code got rid of that. They said, that's baloney, we're not going to do a safe harbor clause anymore. So it was kind of a bummer, because if you were advising a client, it was a big game changer, because now the question is, do you have or do you not have probable cause, right? Because that really is the threshold.
Mm-hmm.
So what oftentimes happens when people have no contest clause is they tend to frame their pleadings taking potentially a pre-death elder abuse angle, saying, Julia unduly influenced our mother prior to her dying to change her trust, to leave everything to Julia, to the detriment of all of Julia's siblings. And they make all these allegations of pre-death things that I did that unduly influence mom.
That way they're not actually contesting the will, they're bringing it under a different section.
Exactly. They're bringing it under the Welfare and Institutions Code, the elder abuse, the financial elder abuse, sometimes the physical elder abuse. But if the will says, I leave 0 to Julia and everything else to her sister Mary, why wouldn't I bring the contest, right? Because I've already got 0, I got nothing to lose.
Yeah.
So that's what happens a lot of times is if you have a child or a beneficiary that's disinherited completely, they have no skin in the game. They may as well contest. And that's when you try to steer everything off into mediation. I have that exact issue right now. Stepdad was married to mom. Mom died first. Mom had 2 children from prior marriage. Stepdad, originally, mom and stepdad had a trust that left everything to the 2 boys in equal shares. After mom died, one son became very problematic. Stepdad wrote him out of the trust in favor of 100% to other stepson. And now he brought an action. He brought an action alleging pre-death financial elder abuse and so on and so forth. Now, the problem is, it's not a huge trust, it's about $250,000, so it's, relatively modest, but this was their stepdad's life savings. And, he's got nothing to lose by bringing it, right? Because he's already getting a big fat 0 under the current documents, he may as well bring it in action. So we are going to go to mediation on that particular action because it's just not enough to litigate, right? I mean, my goodness, we could spend $75,000, $80,000 litigating a $250,000 trust. As I told my client, I said, look, and my client's the one that got it all. I said, I think we can win at trial, but I'm going to spend $25,000 just doing this first little mini trial, and probably another $25,000 on the secondary issue. So that's $50,000. If we go to mediation, maybe we can get your brother out of this for $25,000 or $30,000 because I know we can show the mediator, who's a retired judge, the issues that he's disputing are completely baseless. So at most, he should get nuisance value. He should get the cost of litigation, right? So I said, look, let's see if we can go to mediation, and if we can get rid of this issue within the next 2 months and not have this looming over your head for the next year, that's a good outcome.
Yeah.
Pay him, don't pay me. I have enough work to do. If I was a starting attorney, I might say, oh, let's take it to trial. But I'm not. You know what? Let's get it done. Let's be efficient with your dollars. Give it to him, don't give it to me. Well, I'd rather give it to you. No, you wouldn't. You'd rather get this in your rearview mirror.
Because then you may still have to give it to him too.
Exactly. Because remember, what's a court? A probate court is a court of law and equity. So sometimes judges, if this is the letter of the law, sometimes the judges still will make equitable decisions. And you got to be prepared for that when you're litigating things, right? So, yeah. So the no contest clause has some teeth, but I always tell people, if you give someone nothing, you may as well just open yourself up for a contest. So give them something. I know you hate your son or your daughter or whatever, and they're good for nothing, but then, put $100,000 in trust for them. Now they have to think twice. Okay? So that's a good question.
The other question that I had, just regarding the probable cause part, is even if you bring it and lose, can there still be a finding that you had probable cause to bring it, even
Absolutely.
if you lose?
Yes.
Okay.
Yes. And that is a very subtle point because I've had that discussion with clients. I've said, we've got to make sure you have probable cause before you bring this. And, when you look at the case law on what is probable cause, it's not that high of a threshold. It's not like a preponderance of the evidence, right? I mean, it just has to be enough that it's got some teeth in it. But you better be careful. I have one issue right now with this trust where there's a girlfriend and a daughter with the beneficiaries, and this daughter is Fruit Loop. And seriously, Fruit Loop.
They're always the ones that get the money.
Oh, and when she got half of it, she got 50% of the estate. The girlfriend, who was a longtime girlfriend with the dead guy, got the other 50% of the estate. And her daughter was never around when dad was dying. He's around, like, here, carry the money. Well, he's dead, but he never carried him to his grave like a girlfriend of 8 years did. But putting that issue aside, she has done so many things, and every single issue she's brought up, we have successfully won. I mean, first she tried to bring an action in Santa Barbara County, which was improper venue, so we demurred, and it ended up in India, which was the proper venue, and she's done everything to try and get the girlfriend out of the trust, to the point where she clearly has violated the no contest clause, every way, shape, or form. And so finally, as one of the last straws, we told her attorney, who she's been a challenge too, she is not here in the Valley. We said, look, if your client doesn't knock this off, we're going in for a petition to find that she violated the no contest clause. We're done. We're done with her antics. So you talk to your client, because we think now that we've had 6 separate orders on 6 separate things, every time finding for the trustee, the girlfriend, our client, we think she's violated the no contest clause.
Yeah.
So you talk to your client, because you know what? Our client's done. She is so frustrated with, I mean, our fees on that trust administration, I think, are close to $75,000,
Whoa.
which is crazy. It should have never been that. But, I mean, we have had to defend so many actions against the trustee that were completely frivolous. You know? So we were gonna go in
the
for,
$75,000.
yeah, so we were gonna go in and surcharge her share for this, for most of the fees, because some of them were administration. But we wanted to surcharge her share for all of these excess legal fees, so that my client, the other 50% beneficiary, wasn't eating half of it, right? Because that's what happens. And we wanted to disinherit her completely. If we didn't get the surcharge, if we didn't get the surcharge, we wanted her gone altogether as a beneficiary. So finally, that seemed to, you know, take the wind out of our sails. Because we're like, we're done with this nonsense. And we would have gotten the order, because the judge was so furious with everything she did. Everything. So, but that's, you know, it's important that it be there, because if it's not there, then of course they'll contest. Yeah, people just litigate all day long for the sake of litigating. Okay. Any other questions about the trust? Okay, so we're all clear on a couple of things. We're clear that when you have a trust, you have a pour-over will, right? Okay, and the pour-over will is simply going to say, if you probate it, go ahead and probate it, and then executor, you distribute those assets to the trustee of the trust. Most of the time, the trustee of the trust and the executor of the will are the same person, right? So in effect, you're moving it from a bank account that's in the name of the estate to a bank account that's in a trust. Okay, and then it's up to the trustee to do his trustee job. Okay?
I have a little question about that. So I understand that it sort of has to be probated though for like a minute, right? Is there like?
No, it's not just a minute. It can be probably about 8 or 9 months.
So even though it's going into a trust, the probate is more efficient, right? Than doing all the assets, like having to like account for everything.
Well, no, you're confusing a couple concepts.
Okay.
So first of all, whether it's in a probate or in a trust, you always have to account for everything. Okay? Because a fiduciary duty, there is a duty to account and report under both a probate and under a trust. Okay? Now, when you open the probate, remember that probate process generally takes, at a minimum, it's 6 months. But most of the time, it's about 9 months. Because remember, we have to prepare all the pleadings.
Even for a pour-over.
Yes,
Okay.
that's the thing. It's the same amount of time if you end up having to probate it, even with the pour-over will. Because you have to open your probate, so you have to file your pleadings, get a hearing. You publish in the newspaper 3 times, blah, blah, blah. Your hearing's about 45 to 60 days after you filed your pleadings. Then once your probate is open, statutorily, because remember, a lot of the probate code is statute. It must be open 4 months. You cannot shorten that. So once your letters and your order issue, 4 months to the day is the minimum amount of time you have to have that probate open. Then, once that 4 months has expired, it's not 120 days, it's 4 months. Once it's expired, then you file your petition for final distribution. it gets set for hearing date, which is generally 45 or 60 days after you file it. So if you have 60 days on the front, 4 months in the middle, and 60 days on the back, you're at 8 months.
And that's even with the trust.
That's even with a trust. If you have an asset that's not in the trust that requires probate.
Well, so how do you, what happens if you have a solid will that poured everything in the trust perfectly?
Okay?
You don't need to do any of that then, it just poured it all over, it's
Well,
done?
no, because remember, the thing is when you have the trust, the assets have to be vested in the name of the trust.
Okay.
So on my house, for example, we have a grant deed, right? When you own property, you have a grant deed. You're all familiar with that, having taken real property. My grant deed, the owner of my property is Julia E. Burt and K. Randall Burt, trustees of the Burt Family Trust, dated March 25th, 2003. So if you were to pull up my grant deed on the grantor grantee index at Riverside County,
It's already in
the owner of my property is Burt Family Trust. So my property is vested in my trust.
So you don't want many of these to pour over?
You don't want anything to pour over.
Okay.
Yeah.
Unless it's a testamentary will,
Well,
right, or a
that's
testamentary trust.
That's different. Okay, that's totally different, because a testamentary trust is a trust that comes from the probated will. Okay, this is what we call an inter vivos trust, a trust you establish while you're living. So in a perfect world, you will never have a probate because everything will be in your trust or beneficiary designated. So for example, my house, I own a couple pieces of real estate, they're in my trust. My Schwab investment account is in my trust. My retirement accounts cannot be in a trust because they are accounts where the income taxes are tax deferred accounts, right? So under the Internal Revenue Code, exactly. Under the Internal Revenue Code, they cannot be in the trust, but my trust can be a beneficiary. So on my retirement accounts, my husband is my primary beneficiary. My trust is the secondary. Because I don't have kids, so I just throw it to my trust. If I had kids and they were adults, I'd name my kids, but I don't. Okay, so my life insurance. My husband has life insurance, I have life insurance. My husband is my primary beneficiary on my life insurance. My trust is the secondary beneficiary. So if my husband and I are on the plane to Hawaii and the plane goes down and we, go MIA and drown and dead, what will happen then is the insurance company will get our death certificates, and my trustee in my trust, which is my colleague Heidi, she would contact the insurance company and say, Randall and Julia died. And they'll say, okay, Randall was Julia's primary beneficiary, the trust is secondary, so Heidi will fill out all the paperwork, and all those millions of dollars will go into the trust. Too bad my husband didn't get to enjoy them, but that's the way it goes. Same for my husband's insurance. Since Julia didn't survive, Heidi will collect it and put it into the trust. And then my trust says how it's supposed to distribute. Okay? So when I die, right now, pretty much the only thing that's not in my trust are some of my automobiles. Everything else will flow into my trust. There will not be a probate. Okay? That's the whole idea. Because probate's expensive, right? On $1 million estate, it's $23,000 of statutory legal fees. So I love probates. I'll do probates all day long. It takes me a while to get paid. I mean, I do 8, 9, 12, sometimes 24 months of work before I ever get paid. So it's kind of like forced savings. So you can never count on probates to pay your bills. If you have a probate estates and trust practice, you cannot count on probates to pay your bills because you never know when you're finally going to be able to close the probate, right? You have to count on everything else in your practice to pay your bills. I call probate my gravy. When it comes in, it's like, yeehaw, great. Usually I have to go for taxes or something great like that. But this is just the way, if you run a probate estates and trust practice, you can't count on it. It's like Wally Clark, he does a lot of personal injury. It's on contingency. He didn't know when he's going to get paid on that stuff. But if you have enough of them out there, eventually you can, count on probably then
Keep some of that.
Exactly, but that's the idea. Okay, so does that help kind of solidify in your brain the probate process and pouring into a trust? Now, if there's no trust, it's not a pour over will, then from the probate, it will distribute to the beneficiaries. So if the will says, upon my death, everything shall go in equal shares to my 3 boys, and there was no trust, then in the petition for final distribution of the probate, the executor will ask the court that, pay the attorney's fees, pay the executor's fee as the executor paid it, pay any creditors that need to be paid, if any, and then the rest and residue shall be distributed in equal shares to Joe, Jack, and John.
But the trust still skips all that.
But remember, if you don't have I'm talking about a regular probate with no trust. There is no trust.
Okay.
So the probate will actually be the distribution mechanism. If it's a pour of a will, it pours into the trust, and then the trustee distributes in accordance with the terms of the trust.
Okay.
Okay? So think about it like a pitcher of water. That's why it's called pour over. If you have a trust, the assets pour from the probate into the trust, and then the trustee handles the distribution. Okay? So sometimes we have an executor hat, and sometimes we have a trustee hat. Sometimes it's the same person. Okay? Now, remember then the testamentary trust. The testamentary trust is created when a will has language that creates a trust after the probate is done.
So it still gets probated.
So it still has to be probated. So a lot of times I'll get a bunch of people, East Coast, Washington, they come, they move to California, and they say, I have a trust. I say, bring in your documents. They come in and they go, well, here's my trust right here, it has all this language. No. You have a will that creates a trust, but the only way you get that trust into existence is vis-a-vis a probate. That is completely different than this. Okay? So there'll be language in the will that says, upon my death, all my assets shall go in trust for the benefit of my minor children. When they reach the age of 35, it shall be distributed to them. It still has to go through probate. Right? Okay, so that is the number one reason why we do trust in California is because we want to avoid probate. But I'm very grateful for all those people that don't. I make money on them. Like, I got a call yesterday from one of my clients. She was a woman, she's quite reclusive. I didn't get a call from the client, I got a call from the client's friend. She called me about a year ago, she said, I got your name, I want to do a trust, and she says, but I don't leave my house, I need a house call. I said, fine. So she lived out in the lakes, so we called together. I went out and did a house call. And, had a perfectly lovely conversation, but she's a recluse. She will not leave her house. So I drafted everything, sent it all to her. And I have a little system where, if I don't hear from somebody after about 60 days, we reach out to them and say, hey, I haven't heard from you. You got your drafts, what's up? Go talk to her. She goes, yeah, I gotta focus on that. I'll get to it. Okay. About another 60 days pass, I get a call from her. She goes, I had a fire, and she owns 2 houses side by side. I guess that's more room to stay inside. It did literally knocked off the wall and everything. So anyway, she called me. She said I had a fire in the adjacent unit. Da 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 da. And I said, okay, but really also as a reminder, you still need to get your trust done. She goes, I know. Man, she's worth millions of dollars. And it was really important because she didn't want her family to inherit anything. She doesn't have any kids, and she has some long lost cousins, like somewhere in the middle of nowhere. She's like, I don't want them having it. She was going to leave it all to some friends and to charities. Okay? So we had a long list of charities. Talked to her 45 days ago. I said, client, I just remind you again, you really need to get your trust done. She goes, yes, I'm going to focus on that. And I said, okay, good. I said, do you want me to come see you? She goes, I'm going to finish my list of the final charities and finish my list of my friends who should get it, and then I'll give it to you, and then we'll finalize. I said, okay, no problem. I'm here when you need me. I got a call. She died in her sleep 2 nights ago. So just getting all the money.
Long lost cousin in the middle of nowhere.
Bingo. Already got a call from the long lost cousin's son.
Where's my money?
So the good news is I did have a big probate.
There you go.
It's about $6 million. So I'm happy to do the probate. But what's unfortunate is she did not want these people to inherit her estate. And that is exactly who was going to inherit her estate. And her friend who called me to let me know she died, he was going to get $500,000.
It's not.
Not anymore. Because he's been a dear friend to her for decades. He did everything, because she wouldn't leave the house, so he did all her grocery shopping, everything. Everything for her. I know, isn't that sad?
Yeah.
You should tell the long lost cousin's son, hey.
I'm going to.
Okay.
I'm going to tell her.
Look, you're getting like $6 million or something like that.
I-
I just
and you know
let them know what her intent actually was.
Right.
Like,
Yeah, and that's how
maybe
you
not tell them that like you were gonna be completely disinherited, but say like,
Yeah.
he's gonna get her, he's gonna get this person $500,000
And I'm
for
going to
doing
tell.
A, B, C, and D.
Because I'll tell you what, here's your legal answer and here's your moral answer. I would like to think that my client is wherever she may be at this point, that she's
Dissing
saying,
herself?
Julia, stick it up for, my friend. Because she really cared for him. They weren't intimate or anything. They were just very dear friends. And he took care of everything for her and he should get his money. But legally, these people don't have to do this. This will be a moral, this is what I call karma, I
Yeah.
think they should do the right thing, but I can't make them do the right thing.
I mean, especially if the inheritance is large enough, I'd be like,
Oh, it is. It's like
I mean-
$7 million.
how much?
$7 million.
Yeah. $500,000 out of $7 million?
But I probably RO that and probably take all the charity money.
Exactly.
Because they are gonna get all the charities.
Yeah.
The non-charities are gonna get it.
I mean, it's too bad too, but.
It is too bad because
Yeah.
there were a lot of all local, she only wanted to do local charities in the desert.
Yeah.
And she was gonna help out just about everybody. I mean, so she had a big heart, the kids and everything. So, cousins and wherever, I don't even know. I mean, I'm sure they're lovely, but it's unfortunate. That's the
Yeah.
kind of stuff that happens,
Don't procrastinate.
No, I tell people that all the time. And we've had that happen multiple times. Thank goodness it's not our procrastination, I can document. Because even when I get calls from clients, even if I quoted the client like a flat fee to do the work, I still put in my time billing, telephone call with client, discuss, she's working on her list of charities, and I no charge it, but I document because I don't want someone saying, why didn't you do it?
My boss does the same thing.
Right?
She puts the no charge in there for
Yeah.
all the little things. That,
And you know what? Clients like to know when you become practicing attorneys, clients like to know all the things you do on their file that you don't charge them for.
it looks good to read something in there. I get charged for
It
that.
makes the client feel better. Like when they get a large bill, they can also see that, there's probably about an hour and a half of time that we didn't charge, whether it's indexing the file or calendaring or checking the docket or little phone calls like, hey, you haven't done your estate plan, or little letters that say, hey, we haven't heard from you, you haven't signed your estate planning drafts. I mean, that's an earthquake.
Maybe it's either a train or a base.
Holy moly. If that's a base, that person has no eardrums left. But it sounded like an earthquake a little bit. So I think it's important that you document the file even when you're not charging the client because they appreciate it and it also covers you. Because I'm just saying, oh, thank God that I tried to get this lady to sign everything because I don't want the friend over here saying, you failed to get this signed by the dead woman. It's your fault I didn't get my $500,000. Right? You can hear that coming, right?
Mm-hmm.
I mean, he didn't know it said $500,000. I don't know. No.
Right, find it in her house.
And I said, hey, she had the drafts. Did she sign the drafts by chance? Right? Because when I send out drafts to client, I always have a big draft, right? So even if she had signed them with drafts, I couldn't enforce it. I said, did she sign the draft? And he goes, no.
Everything has list of charities as a will, right? Yeah.
If she would have just signed that draft before she died, could have gone with it, could have worked. Testator intent, right? This is what she intended. Testator does not work, testator intent does not work with unsigned documents. There's not a court that's gonna give you that. Okay?
But even if she signed the draft, was it a trust?
She had a pour of a will,
So
she had a trust.
even if it was just signed, would the court still accept it if it wasn't notarized or?
Yep.
And
I could have gotten that,
trusts don't have to be witnessed, right?
Nope.
They just have to be notarized.
correct. And they don't even have to be notarized.
Well, they don't have to be notarized?
There's no requirement under the code that they be notarized.
Oh,
It's best practices if you notarize them.
how come the requirements are so much less for a trust than they are for a will?
Good question.
Oh, you think
Because they
there's
just
no
have,
reason?
there is just the rules with wills with, but remember, a holographic will, no witness is required, right?
You were still on your handwriting.
Right, if it's in your writing, but if it's a will that's drafted by an attorney, then the requirement is 2 witnesses. Now, I have gotten wills without 2 witnesses,
That's
admit
like
it.
from with error.
as long as no one objects. If no one objects to it, it gets admitted.
Mhm.
But best practices is 2 independent witnesses with your attestation clause.
But just in a will.
Just
Not
on a
in a
will, not on a trust.
No, she had the trust, but she hasn't moved, like, necessarily her house into it yet, or things like
Nothing,
that.
because she never signed it.
So you still have to
Never-
probate all that, you just have the intent, right? You'd have like where
But I
it's
don't
going.
even have the intent because she hadn't signed it.
Right, no, but I'm
But
saying,
had she signed it, let's
Right.
just say she had signed that the night before she died, let's say she had signed it.
exactly.
Because she thought, I'm dying tonight, I can't breathe.
So you'd have to probate that.
Then I'd have to probate
Okay.
it, and then I'd have to get it distributed to the trust. So if she would have signed that horrible will and that trust before she died, even in its draft form, I could have dealt with it. I could have gotten that admitted. Now, the relatives might have, started raising some objections. Maybe we might have compromised a little bit, but I could have gotten it admitted. Mhm. But she didn't even do that. Because I said, hey, go in her house, see if the drafts are signed. He goes, no, they weren't. I go,
Now he knows what he's supposed to get.
yeah. And the coroner, of course, took his key, so now he can't get in the house anymore. Because once they because he found her dead. Because he already went and checked on her every day. So he went in the house on, let's see, he called me. Today's Wednesday, he called me Monday. So he went in the house on Sunday morning to check on her. And she was dead. So, poor guy. Not only is not going to say now he's got that searing memory in his brain. Really? That's just like that. Yeah. Okay. All right. So are we clear then? Trusts, wills, pour-over wills versus standalone wills, and how a testamentary trust is created. Because it is so vital that you understand these concepts. And now that I have to tell you, when I went to law school, my law school professor never gave us a trust. And it was very hard for me to understand, like, what are they talking about? But then once, I saw it and I started practicing, obviously, I go, oh, I totally get this now. But it's really a hard concept to understand unless you can kind of see the documents. Yeah, our teacher was very, textbook, just Socratic method, nothing practical. I don't think she ever did wills or trusts. She understood it, but she never practiced. Okay. And since I'm a practitioner, that's important to me. Okay, so what are trust characteristics creations? I want to just look at my little notes in the book to see if there's anything else I want to touch on, because we've, irrevocable trust. Let's just touch on those for a moment. So this is an inter vivos or revocable trust, right? Means as long as you're alive in your capacity, you can amend it. You can revoke it in its entirety. You can put new assets in it. You can change beneficiaries, whatever you want to do. A lot of times we will do irrevocable trusts. And so you're saying, why would we do that? Let's say you're the number 2 Google employee and you have founder stock, right? That has low basis, and you think this was, let's just assume we were 20 years ago. And it's going to be a hit, right? This was at the advent of the internet. So thinking, of course, that we have our estate tax, right? Remember, if you have a large estate, you always have that federal estate tax looms. In California, no estate taxes. Other states, yes, in California. So if you transfer assets into an irrevocable trust for the benefit of siblings or children or whomever, those assets then come out of your estate. Whoever the grantor was, they're out of your estate for estate tax purposes. And if there's appreciation in those assets, now that accrues to the beneficiaries of that irrevocable trust. Okay? So that's one reason to do it. It's wealth transfer, right? And it can be a very effective way to wealth transfer. Other reasons we do it is it gives creditor protection. If you are a wealthy person, or if you have certain high-risk occupations like neurosurgeons and plastic surgeons, right? They're always getting sued because someone gets their face turns out lopsided, or, they nick a nerve and they're come up paralyzed. And of course, it's always the physician's fault. It's not the fact that the patient has any liability. If you have assets in irrevocable trust and you get sued and the claim goes beyond your malpractice limits, then the creditor cannot attach to assets within that irrevocable trust. Okay? So you will oftentimes see people put assets in irrevocable trust for creditor protection.
But can you use the funds in an irrevocable trust like you could in a revocable trust, or no? Because technically, once they're in the irrevocable one, they're vested with whoever the beneficiary is.
So it depends upon who the beneficiary is, exactly. So if the beneficiary are your children, no, you cannot use those funds. Your children can use those funds.
So it's kind of like a trust fund type
Exactly.
trust.
So there could be trust for the benefit of the children, and they can be used for education purposes, all sorts of things, right? But if you as the grantor grant those assets into the irrevocable or irrevocable, I say irrevocable, trust, your hands are off of it as far as ownership and getting the beneficial use of that. You don't get to use the money. It accrues to the beneficiaries.
So can you still be the trustee of an irrevocable trust?
Good question. Yes, you can.
So you still can use it like a revocable trust as long as you're the trustee
No.
as well, or still no?
No, you can't use it for your own benefit. Because if you use it for your own benefit and then you've got creditors chasing you,
Then you.
they're just going to collapse that irrevocable trust and say, yeah, this is a sham.
Okay.
You set this up to avoid creditors and you're using this money like it's your money, you give it to us.
So that's more like a savings type thing. Like I
It's like-
know I'm never gonna need to touch this, so.
Right. Yeah, and now the grantor can be the beneficiary of an irrevocable trust, okay? So that is possible. You can set up an irrevocable, like an asset protection trust, and the grantor can be the beneficiary. But if you then have creditors, they can get what's called a charging order. So if the irrevocable trust has distribution of income, they can say, I may not get at that principal, but give me all your income. Okay? So if the trust,
Do you only income like interest that is off of it? How
it
else do you get
depends
income?
how, yeah.
Like if it's an annuity, I guess,
It
but
would
even
be-
still.
Like if it's stocks and bonds, you get interest distributions or you get dividends.
Oh, okay.
Yeah. Or if it's, let's say that irrevocable trust owns real estate, you might get net rental income. So if a grantor is the beneficiary of an irrevocable trust, like an asset protection trust, and they are getting distributions, creditors can definitely get at those distributions.
Just at the grantee's own benefits.
Yeah, if the
Right.
grantor is accruing benefits as a result of that irrevocable trust.
So no one else's benefits, just the grantee's benefits.
Correct. So if, let's say there were 10 beneficiaries of that irrevocable trust, including the grantor, then the argument would be, fine, you can have 1/10 of the income under that charging order, but you're not gonna get 100% because there's 9 other beneficiaries of it. Okay? So, generally speaking, I don't like having my grantor being the trustee of an irrevocable trust. I don't think that's good practice, especially if you're doing it to potentially thwart future creditors. And of course, if you have known or ascertainable creditors, it doesn't matter. You can't basically do
Can't hide your funds.
irrevocable trust because it's a fraudulent transfer, right?
Mhm.
They're gonna crack down on that in no time. So once in a while, like maybe 2 or 3 times a year, I get someone that comes in and says, I need creditor protection. What's going on? Right? Are you being sued? Well, yes. What happened? Well, I defaulted on a loan and they're suing me on the personal guarantee. Well,
Too late, yeah.
Sorry, should have thought about this 3 years ago before you defaulted. That would have been good planning, right? Because if you're insolvent or you already have creditors chasing you, it's a fraudulent conveyance, okay? All right, so that's the irrevocable trust. We talked about life estates. So we talked about testamentary trusts, very good. There's a nice Ask Ann Landers column. Yeah, you probably already read it. Let's see. Oh, there's a cute little thing on 423 about the tax on the dog. See, I love this book. It's actually really, I don't know, it's much better. And of course, the trouble with me on home super. I will ask Nicole next week, or Heidi, we can talk about Leona home sleeps. I'm gonna mark that for Heidi, page 426. That's good one, because we're running out of time here. All right.
I still don't understand the whole secret trust thing. Like,
You know,
is it not even worth really
Don't even-
worrying about? Okay.
It's not gonna be on wills and trusts.
Okay.
It's silly, we don't really.
Yeah, because it's like I left a will without an intent to create a trust, but somehow I'm going to create a trust.
I don't spend any time in that. I've never seen that bar tested. We're not gonna test on it. It's such an antiquated notion because there's so much case law on what trusts are supposed to be. Hold on 1 second. Let me just reply. Okay, so, questions? Anything? Okay, so you've got a question that has 6 parts. And you need to use your book or look online or whatever. And in a way, I don't really want to answer questions because I want you guys to, we've touched on every one of these subjects. To some degree, we've touched on them very briefly. If you don't know the question, look it up. But it has, I think you can all answer this, but it's, you know, it makes you think, okay? And you guys know what I mean by total estate, right?
Wait, total estate, like
Yeah.
everything?
Right, total estate. ESTAT means estate. Everything we got, right? Okay. Yeah, you guys can answer this question. It might take a little time, but it could take an hour. Okay. All right. Okay, so clear, no more reading. Heidi will cover non-probate transfers and planning for incapacity next week. And then the following week, Nicole is going to do review and midterm prep. And then you'll have 2 one-hour essays for your midterm. Okay? All right?
You get
My
to like
emails,
Saturday, right?
my email, Julia, Julia, at juliaburtlaw.com. So JuliaBurtlaw.com. Okay? And I mean, you guys can talk about it together, but try not to. Try and like weasel your way through it. Not weasel, will your way through it. If you need to look up things, do that. You know, that's fine. Okay? All right?
And you said by Saturday, right?
Just by Saturday sometime.
No.
Okay? Because you don't have to do any more reading
For this class.
for this class.
Well,
Yeah, no, that's true.
this was the, you
This
know,
was the big heavy reading class, yeah.
I know, but you see how, you know, the problem with Wilson Trust is you have to learn a lot because this all builds on each other.
Professor Drucker said that is usually a 2-semester course too,
Yeah, I know.
which is, I'm like,
I'm
dang.
slamming, so you really have to front end a lot of the concepts because then after the midterms, we start dissecting a few things that you get a little bit more. But if you don't know the basics,
Yeah.
then, you know, what can I say?
Yeah.
You gotta know test stage and test stage, you're not wrong.
Yeah.
So that's why it's really intensive at first, but it is fun.
okay, it's an interesting book, you know,
Yeah,
it's kind of funny at times.
I think so.
Yeah,
Cartoons.
it's not like reading a Tomahawk
Cartoons.
book, you know, where it's
Oh,
like
you know, I can't stand that stuff.
one
I
terrible, like,
I hated
boring story after another.
Come on and Cipro.
I hated it. I didn't like evidence. So.
I hated evidence, but I have a finer appreciation for evidence, having now done trust and probate litigation.
That's my opinion about CivPro now. Class, I think was terrible. It was like a horrible experience, but I really like it in, you know, in practice. Like,
Yeah, because, you know, I didn't really, I'm never gonna use this stuff. Why am I wearing it all? Correct.
I'm gonna steal my jurisdiction.
Now, I never use common law, so I'm good with that. But yeah, it came back to bite me. I should have probably paid a little bit more attention to evidence.
Thanks, Professor.
Thanks, you
you.
guys.
Yeah.
Okay, so I'll see you guys in a few weeks.
Yes, ma'am, have fun.
And,
everybody.
Enjoy your vacation.
and enjoy the other gals, okay?
Take it.